Welcome to the Probate Nation. As loved ones age, they often need assistance making their care and financial decisions. And frequently, a family member has to petition the local court to obtain that legal authority as either a guardian or conservator. The process to be appointed to those positions is like a carefully choreographed play with many actors. There is the petitioner, the respondent, attorneys, the circuit court judge, and possibly a jury, and each has a different role to play. But there is much confusion about one other actor in this process, namely the guardian ad litem, or GAL. You see, when you file that petition, it triggers the court to appoint a GAL. The question is, what is the role of the GAL? How is the GAL different from the guardian the petition seeks to be appointed? All good questions, and I suspect you will have many more. Let me introduce you to two local attorneys who, over the course of 2 shows, will answer those questions and much more. Our first guest is the founder and owner of Bromley Law in Fairfax City. His practice focuses on probate, trust, estate administration and litigation, and guardianship law. He previously served as co-chair to the Fairfax Wills Trust and Estate section of the Fairfax Bar Association, and has also been a law clerk for the Fairfax County Commissioner of Accounts. He serves as a court-appointed GAL for incapacitated adults in Northern Virginia court proceedings. Our second guest is of counsel with the Meyerson Law Group in Reston, Virginia. His law practice covers both civil and criminal matters, including business and contract matters, civil litigation, and criminal and traffic defense. He has served as a GAL for incapacitated adults in guardianship and conservatorship proceedings in Fairfax County since 2010. Please welcome attorneys Jonathan Bromley and David Hirsch. Hi, gentlemen. Thank you for joining us today.
Thank you.
Thank you for having me, Richard.
Oh, you're very welcome. You know, Jonathan, let me ask you, start off with, what is the role of the guardian ad litem in this entire play that we're going to talk about?
Well, every guardianship by law requires that there be a guardian ad litem appointed to represent the alleged incapacitated adult. That's the topic of the proceeding. The primary role of the guardian ad litem is to look out for the best interests of that person. He's going to have to meet with him, interview people, make sure that that person understands what the case is about and advises them of their rights, and make recommendations to the court as to what the judge ought to be doing in that particular case.
So how is the GAL role different from the actual guardian that's going to be appointed in the court process?
It's a really good question, Richard, and I think one that confuses a lot of people unfamiliar with this area of the law. A guardian is the person who's appointed to represent the serve as the decision maker for the incapacitated adult at the conclusion of a case. It's a fiduciary. The guardian ad litem, on the other hand, is only involved in the case itself to look out for the best interest of that person. And ad litem is actually Latin for in this proceeding. So while a guardian would have authority to act for the person when the judge decides that that's a suitable individual, the guardian ad litem's role is essentially to be a fact finder and to let the court know, again, what it ought to be doing.
Well, David Hirsch, let me ask you this. You know, we talk about this guardian ad litem, so tell me, can anybody be a GAL?
No, not anybody, Richard. First, you must be a licensed attorney, licensed in Virginia and in good standing in the Commonwealth of Virginia. And then if you wish to do this, you have to take a qualifying class. It's a 6-hour class. And additionally, you must either follow an existing guardian ad litem for 2 cases, or serve as counsel for a petitioner in 2 cases, or have to end up having been appointed as a guardian ad litem in 2 cases. So you have to meet all those criteria before you can serve.
Okay, so it is a somewhat complicated process for someone to become a GAL, but they are trained in order to handle these types of matters. Let's go on to the next area as we go into the third act of our play here, and let's talk about the how do we select the GAL? So, Jonathan, how is a GAL selected in a guardianship or conservatorship case?
Well, the short answer, Richard, would be the judge. Guardian ad litem can only be appointed by the court. Now, in the different circuits in Northern Virginia, and really throughout Virginia, judges are provided with different options. In places like Fairfax County, for example, we have a lot of people in the area who are certified to be guardian ad litem. So the courts, for example, would usually look at a list that it keeps and go through that list in order so that make sure that all people who are able to serve have an opportunity.
Sure, and I know that you're right. I think the process in Loudoun County or Prince William County or frankly Arlington can be a little bit different, because it was at a time in Fairfax where you could actually pick your GAL when you petitioned the court, but they changed that some time ago. Let's jump ahead though to the investigation process. David, let me ask you about this. What exactly is the authority of the GAL once appointed by the court?
Well, the authority is fairly sweeping. It is to go out, investigate the merits of the case, find out what the facts are, and make a report back to the court. That report is to tell the judge what the facts are that have been found, as well as to make recommendations as to what would be in the respondent. That's the person against whom the guardianship is sought, what would be in their best interest. So we have authority to look at a wide variety of records and talk to a wide variety of people.
Well, let's talk about that. It is a broad authority. Let's drill down a little bit and talk about the investigation that a GAL would do from a document perspective. So tell me about some of the, what kind of documents would someone want to look at if a child was just turning 18 versus an adult that's maybe accumulated some assets?
Well, for a child who's just turning 18, I would want to I'm required to look at the most recent IEP. That's their Individualized Education Plan. That's a special education plan. I'd also want to see if any bank account records have been set up for that child, as well as medical records. Each GAL petition or guardianship petition is required to have a medical evaluation as an attachment, and I would want to look at that medical evaluation. For an adult, it's similar. You don't have the IEP, but I'm looking at financial records, asset records, the medical evaluation, and any other medical records that may be pertinent.
And how do you go about looking at those those financial records, especially? I mean, how do we get to those?
Well, I take to the banks. I get a certified copy of that court order of appointment, copy of the code section requiring the financial institutions to apply, and I bring those in person to a bank branch and request the records. A lot of times, various family members have some records too, and they often provide those. Okay.
So I know it's been a little bit challenging sometimes with these banks as far as what they'll let a GAL look at. Because they want to see certified raised seal orders and things of that nature. They won't take copies of the GAL order, so that can be a little bit frustrating. Let me just ask here, what about, you talked about review of educational records, medical records. How about the doctors, though? What kind of records do you want to look at from a medical perspective?
I would like to see not only evaluations, but history of any illnesses or treatments, particularly recent illnesses or treatments. And sometimes, even if there has been an evaluation by one provider, there are some standard evaluation forms. I'll ask another provider to provide an evaluation, especially if it's a close case and we're not really certain to what level of capacity or cognitive function the person has. Then I'll ask the doctors to complete that additional evaluation, so I look at that. And sometimes we even request that a formal neuropsychological evaluation be conducted, which is an exhaustive examination and can be expensive.
Yes, and it is very helpful if the respondent is over the age of 65, that with the appropriate referral, I believe that Medicare will pay for that evaluation. But Jonathan, let me turn to you now and talk about the GAL investigation as far as the people that are going to be interviewing? Who should the GAL or who might they talk to in that process?
Really, it's going to depend on the case, Richard. You know, there's the obvious. First, obviously you want to talk to the subject of the proceeding, the person who's alleged to be incapacitated. You're going to want to interview the petitioner, the person that's requesting guardianship, to learn a little bit more as to how we got here. You'll talk to friends, you'll talk to neighbors, you might talk to care providers, if the person's in an assisted living facility or in a nursing home. The code, actually, the General Assembly recently modified the code to make sure that the guardian ad litem actually requires the guardian ad litem to talk to the individual's primary care provider or primary doctor. So it's really open-ended, Richard, in terms of where the GAL feels they need to go in order to get the information they need to make recommendations to the court.
Sure, and that goes to the whole fact-finding. Now, David Hirsch, should the GAL talk to the attorney for the petitioner?
No, absolutely. And you need to find out, there may be some gaps in what's been provided or information provided, so that needs to be found out. A lot of times, the initial filings don't have the contact numbers for family members, and so we need to reach out to the petitioner's counsel, get the contact information for the family members we are to interview, and also get a sense of what the goals are. I mean, sometimes the code has a variety of options. There are full guardianships and conservatorships. There can be limited guardianships and conservatorships. So you really want some idea of what's the goal of this filing. So there's an ongoing dialogue with the counsel for the petitioner, and also if there's a counsel for the subject of the petition, the respondent, an ongoing dialogue with that attorney as well. And sometimes other family members get attorneys, so it can be quite a lively conversation.
Well, I know you've been part of many of those lively conversations. Jonathan, let's talk a little bit about, I'm the GAL. One of the people I have to go ahead and visit is going to be the respondent. Tell me a little bit about what is the purpose of the GAL visiting the respondent, the person that actually is the subject of the petition where we believe they may be incapacitated and need assistance.
Well, it actually serves multiple roles, Richard. I mean, on the one hand, obviously a guardian ad litem is going to have a difficult time making recommendations to the court unless they actually meet the person who's alleged to be incompetent. So, by visiting with them, by speaking with them, you're going to get a better sense as to their capacity, what type of decisions they can make, and their ability to understand information. But from a statutory standpoint, there are requirements that the person who's being alleged to be incapacitated be served formally with process. In other words, the guardian ad litem is required to hand that person the petition that's alleging they're incapacitated, to hand that person a formal notice that advises them of their rights and of what type of civil rights, like decision-making authority for themselves, they might lose if in fact they're declared incompetent. These documents are actually, this service is actually jurisdictional. The court cannot proceed with the case unless the guardian ad litem visits the respondent personally, provides those documents, and informs the respondent of their rights in the case.
So the documents that are going to be served on them, of course, would be the pleading. Now, you mentioned this notice. Is there some sort of formal document? In other words, is there some sort of statutorily required document that needs to be served? Is that part of the process as well?
Yes. There's a written notice that's typically prepared by the petitioner's attorney that advises the individual of the anticipated court date, their rights in the case, what the consequences of the case are, and that has to be not only given to them, but a good GAL will actually try to explain it to them the best they can, depending on the level of capacity and their ability to understand. So, for example, in a case that involves a child that's about to turn 18, I might explain things a little more simply. Rather than using legal terms, I might explain that, for example, your parents are asking to continue acting as your parents into your adulthood, rather than try to explain that we're going to ask the court to declare you incompetent and to appoint your parents as your guardian.
Sure. So there's a purpose behind this process, and I gather there's a formality, I think is what you're telling me, about how we go about and actually officially do our duties as a GAL in order to be able to report accurately and truthfully to the court what has been done, because the court's relying on you to make sure you do those things with that very, very formality. So it's very important. That's a very important thing. David, I'm going to come back to you now, because we've talked a bunch of stuff about in the initial process, and we have a long way to go in sort of explaining the GAL's role here. But tell me, what are some of the common problems that you have seen that as a GAL, that you face as a GAL over the years you've been doing this?
Well, the first case I ever had out of the gate, the respondent told me there was no way in HE double hockey sticks he would allow me to come in and talk to him. So fortunately, he got a lawyer, and that was smoothed over. But more typical ones are the attorneys think that the GAL is a party to the case and wants the GAL to engage in what is called the discovery, which is common in civil cases. You exchange information, written requests for answers, documents, and that really is not proper for a GAL. The other thing I've run into a couple of times, one more recently, is one of the attorneys in the case listed me as one of their potential witnesses in the trial. And I said, absolutely not. You cannot go there.
Jonathan, how about yourself? What are some of the challenges that you have run into or problems that you've seen as a GAL over the years that you've been doing this work?
I think one of the biggest, and it's very particular to the DC area, we have people from all over the world that live here. And so as a result, you end up having people from different parts of the world who speak different languages and have different cultural customs. So in some cultures, for example, it's customary that, the oldest son, for example, kind of speak for the family. But you need to talk to other family members. So sometimes you kind of have to schmooze your way through the process. You might need to get a translator to help you communicate more effectively. But really, it's I think just being a nice guy kind of gets you through some of those barriers to entry. Especially as David mentioned, you show up to meet with the incapacitated person. He's not happy to talk to somebody about his level of capacity. So, just coming in and being friendly, making some small talk, discussing baseball, sometimes gets you in the door and just kind of lets you have a better assessment of what these people are capable of.
How often do you see as a GAL a problem that you identify early on about the proposed guardian or proposed conservator not being able to be properly bonded with surety? Do you?
So with surety is an interesting thing. So surety is essentially an insurance requirement on the handling of somebody else's money. But before the court appoints somebody as conservator, they're going to want to make sure that if they're allowing somebody else to handle this person's money, that they have an insurance policy, again, to make good in case that person steals or robs or just loses their assets.
Sure.
So in some cases, a person is not able to be bonded. It might be because they have a history of bankruptcy or poor credit. It might be because they have a criminal record that makes the court uneasy or an insurance company uneasy about underwriting that insurance policy. So when that comes up, we usually have to look for other options, maybe other family members or maybe local practitioners that are able to get that type of insurance policy.
So generally that's going to come up, though, as part of your people investigation of the petitioner. You're going to learn more about their background, and when you hear about those types of issues, that's going to automatically trigger a concern that we need to check out that bonding issue. David, I want to ask you, because I know you've been involved with a lot of litigation as a GAL. How often have you encountered folks attempting to take the GAL report and admit that as evidence?
I think I've only had that happen on one occasion, and it was quickly taken care of.
So the idea, again, consistent with your conversation, your explanations, the report itself is really for purposes of educating the court as to what direction they should go, what question they should be asking, and so on. It's not intended to be some sort of an evidentiary document to be used against anybody in the proceeding per se.
Correct. And the other thing is, and I know we're getting technical here, but a lot of what's going to be in my report is hearsay. That means it's information provided to me by third parties. So as we know, in court, generally hearsay is not admissible. You need the actual person who made the statement there to provide it in court.
Excellent, guys. This has been very, very helpful. We got a lot more to cover as we sort of continue this, the next, chapter of this particular play that we're going to see. But how about up to this point? How about if I ask you, David, since I have you on the screen, can you share with us some final thoughts on our discussion so far about the guardian ad litem's role in this, this legal proceeding that we're going to be talking more about?
Sure. I view my role as an independent voice for the best interests of the person who is the subject of the proceeding. That is my role. I'm there to be an independent voice for their best interests. And part of my role, too, quite frankly, is to protect our judges from making a decision that bounces back. No judge wants to see their name in the newspaper for something that went south. So my job is to see that the respondents' interests are protected to the full extent of the law, and to make sure that the judge isn't led into making a decision that is unwise under the facts or the law.
Well, that's very good. And Jonathan, how about yourself? What are some closing comments and suggestions you might want to share from our discussion so far in this show?
Well, the guardian ad litem is an integral part of this process. And in a lot of ways, it's really the fail-safe. Anybody can file a petition and ask for relief, whether it's in a guardianship or any type of lawsuit. But in this context, you're essentially there to make sure that what the petitioner is saying about the person is true, especially in cases that are uncontested or where the person's not able to advocate for themselves. And what a lot of people don't realize is most of the lawyers that do this work are paid by the states, since the individual might not have any assets. It's a very low-paid job, and it wouldn't work unless we had lawyers throughout Virginia who were willing to provide their time to the courts and aid the court in making these determinations. So it's very commendable when lawyers step up to get educated in this role and to provide sometimes dozens of hours at a rate far below what they can make in private practice.
I think that's one thing I think we want to take away from this initial discussion, is that people shouldn't be angry with the GAL because they're really just trying to provide a service to the court to facilitate the entire undertaking that the petition has launched. Well, guys, look, we're going to have to take an intermission here in this particular play, and I want to thank you for Jonathan Bromley and David Hirsch for sharing all this information that you have during the first part of our program, this part one. And I hope that I can ask you guys to come back and pick up the conversation when we do part two of this show, so we can kind of close all the loose ends and help people be better educated. But thank you very much for this great public service.
Thank you, Richard.
Thank you, sir.
There's much to be done to successfully prosecute a petition to establish a conservatorship and a guardianship. And a key contributor to advancing that petition is the court-appointed guardian ad litem. In part one this evening, our guest introduced you to the role of the GAL, how he is selected by the court, and the scope of his investigation. But there is much more to be covered to complete this conversation. Next week, in part two, you will learn about the rights of the respondent, the importance of the GAL report filed with the court, the role of the GAL in uncontested and contested petitions, who pays for the services of the GAL and others, and much more. We encourage you to tune in. This concludes our show this evening. We hope you found it informative. Just a reminder that replays of this show can be viewed on the Probate Nation website and YouTube channel. And if you want to receive monthly tips on guardianship, conservatorship, and probate, please sign up for the free Probate Nation newsletter. Until next time, I am Richard Ruddy, and this is the Probate Nation.